Hi everyone, let's talk about breach of contract and remedies. In this lesson, we'll describe complete, substantial, and inferior performance of contractual duties. We'll examine the kinds of monetary damages that can be awarded in the event of a breach of contract. We'll explain mitigation of damages and describe when this is required. We'll describe rescission of a contract and the payment of restitution. We'll describe the equitable remedies of specific performance, reformation, and injunction. We'll identify when contract disputes are to be resolved using arbitration, and we'll describe torts associated with contracts, including the tort of bad faith. So for an overview, there are three main levels of performance of a contract. One, involving most contracts, is complete performance, where everybody does what they say they're going to do. Next is substantial performance, where we get pretty close, but with a minor breach. And then finally, we have inferior performance, where there is a material breach of the contract. A breach of contract is defined as if one or both parties do not perform their duties as specified in the contract. Remedies, usually we're talking about money with contract disputes, so the most common one is monetary damages. If monetary damages won't work, the court could award a few kinds of equitable remedies based on the concept of fairness. Complete performance is when a party to a contract renders performance exactly as required by the contract. When both parties have performed, this results in an executed contract. Both parties are then discharged from any further obligation. This, again, is how most contracts are completed. Most people just do what they say they're going to do. We define tender of performance as the unconditional and absolute offer by a party to perform their contractual obligations. This is a legal term just for vocabulary purposes. It basically just means you're offering to do what you say you're going to do under the contract. So I tender by offering to pay the money I owe under the contract. The other party can tender by offering the goods under the contract. Substantial performance. When we have performance that deviates only slightly from complete performance, resulting in a minor breach of contract. If the breaching party does not correct the breach, the other party can sue to recover damages by, there's a couple different things you can do here. One is you can deduct the cost to repair from the contract price and then pay the balance, or you could sue to recover the cost to repair the defect if the breaching party has already been paid. As an example, I make a deal with a contractor to build me a new 3-bed, 2-bathroom house to be painted blue. Total cost being $200,000. The contractor builds the house, finishes it, everything looks great, but the only problem is that it's painted pink instead of blue. It will cost me $3,000 to fix the paint color. I have a few options here. One, if the contract fixes the color on their own, the contract is performed and I owe the full $200,000. Next, if I have to hire somebody to fix the color, I can deduct that $3,000 cost from the price and pay the balance of $197,000. Lastly, if I had already paid the contractor the full $200,000, which would be a bad idea, and the contractor won't fix the issue, I can then try to sue them for the $3,000 cost of repair. Next is inferior performance. When we have a material breach, one party fails to perform, express, or complied contractual obligations and impairs or destroys the essence of a contract. There's no clear line between what a minor and material breach is. The determination is made, usually by a court, on a case-by-case basis. A non-breaching party is permitted to, in the event of a material breach, they can rescind the contract and seek restitution, aka try to get their money back, or they can sue to try to enforce the contract and seek damages. Sometimes a party indicates ahead of time that they do not intend to perform their duties under a contract. We call this anticipatory breach. In this event, the non-breaching party can immediately be discharged from their contractual duties, and they have the option to sue immediately. Or they can wait until the time for performance and then sue then, but why waste time? Monetary damages, as the name would imply, are an award of money. They're available to non-breaching party upon minor or material breach. There are several different kinds of monetary damages. So let's talk about the different types. We have compensatory, consequential, liquidated, nominal, and punitive damages. Compensatory damages are an award of money intended to compensate, as the name would imply, a non-breaching party for the loss of the bargain. The idea here is to make both parties whole, or at least the injured party whole. The purpose is to place the non-breaching party in the position it would have been if the contract had been fully performed, restoring the quote benefit of the bargain. For compensatory damages, the amount awarded depends on the type of contract and the party that breached the contract. Some types of contracts where compensatory damages are applied. These aren't every kind of contract where they're applied, but some. Sale of goods, construction contracts, and employment contracts. We'll mention those briefly just so you get an idea. For a sale of goods contract, the usual measure of damages is the difference between the contract price and the market price of goods at the time and place they were to be delivered. As an example, Bob contracts with Joe to purchase 100 bushels of wheat at $20 a bushel. Joe doesn't deliver, so Bob has to purchase elsewhere, but at $25 a bushel, a higher price. Bob could sue for the difference of $5 a bushel plus court costs. In a construction contract, damages are going to depend heavily on the stage of project completion and contract language. If the owner breaches before the project starts, the builder can sue for anticipated profit they would have made. If the owner breaches mid-completion, the builder can sue for anticipated profit plus whatever expenses they have incurred so far. If the builder breaches, the owner may sue for the difference between the contract price and the cost of hiring someone else to build, finish, or repair the project. And there are a lot of other scenarios there, but those are just some examples. In an employment contract, if the employer breaches the contract, damages can include lost wages or salary, including back pay, front pay, lost benefits, etc. It could also include emotional harm, just depending on what happened, if there maybe was some discrimination or some bad treatment, and maybe some out-of-pocket expenses as the result of a job search or medical expenses if those are incurred. The compensatory damages that are going to be awarded in an employment contract are going to be subject to some federal and state limitations on the amount of damages that are possible. For instance, in a federal employment law case, there is a hard limit of $300,000 available as compensatory damages for a very large company. For very small companies, it could be as small as $50,000 available as a cap on those compensatory damages. Now, if the employee breaches, the damages can include the cost of hiring a new employee, and if I have to hire a new employee at a higher salary, maybe even the difference in the salary. Switching to consequential damages, these are foreseeable damages that arise from circumstances outside the contract. Keyword there is being foreseeable. The breaching party must or should have known that these damages would result from a breach. An example would be that a builder who is building a business's location doesn't get it done on time. The business could sue for anticipated profit lost until the project is completed. One important thing about consequential damages is that they can be disclaimed in a sales or license agreement. And most modern contracts that I've seen do have some type of disclaimer in there, disclaiming consequential damages. If that clause is in there, there's a high likelihood that a court would not enforce any consequential damages against the company because it was in the contract that they are disclaimed, thus they are unavailable. Nominal damages are a very interesting type of damage. It results when the non-breaching party sues the breaching party, even though there's no real financial loss that has occurred. These cases are usually brought on some type of principle of who's right and who's wrong. Nominal damages are usually awarded in a very small amount, such as $1. Hey, you're right, but you didn't suffer any loss, so here's $1. Most courts don't like dealing with them. Punitive damages are, as the name would suggest, designed to punish a bad actor when their behavior is found to be especially harmful. They are awarded, if they're awarded in addition to compensatory damages. They are typically only awarded for intentional torts and or wanton and willful misconduct. Very rare to see them in contract disputes because the goal in contract disputes, as I mentioned earlier, is just to make the other person whole. as if the contract had been completed or as if the contract had never existed. So punitive damages are rare, and we usually have to have a court find that somebody did something especially bad. Both parties are required to mitigate damages, especially a non-breaching party. This just means we have a duty to avoid or reduce damages caused by a breach of contract. Mitigate just means to lessen the severity of something. The extent of mitigation depends on the type of contract. If an employer breaches an employment contract, the employee must try to mitigate damages, should try to find substitute employment, can only accept comparable employment. So putting this into context a little bit, let's say if I have an employment contract, but my employer breaches and now I'm out of a job and I should have been paid $5,000 a month. I could sue for $5,000 a month until I find a new job, at which case those damages would stop accruing. So that means I have to actively go out and try to find employment. I can't just sort of sit around and hope the company pays me forever what I would have been paid under the contract. I do have that duty to try to mitigate those damages. Liquidated damages. Okay, these are when a party when both parties agree in advance that certain damages will be available if the contract is a breach. So we agree ahead of time on the amount of damages in the case of a breach. What we have to show is that actual damages must be difficult or impracticable to determine, and the liquidated amount must be reasonable in the circumstances. So we could agree ahead of time. Let's say we had a construction contract. We could agree ahead of time that if the contract is not completed on May 22nd, we could say, well, let's include a liquidated damages amount of $1,000 per day beyond the performance date. So every day beyond May 22nd, we could say that the builder has to pay a fine of, or liquidated damages amount of $1,000 per day. Now, I have to be careful that my liquidated damages are not considered to be a penalty, which would count as punitive damages. If the actual damages can be clearly determined in advance, or if liquidated damages are excessive, the court could determine them to be a penalty and thus not enforce them. So we have a case here, Burke versus 401 North Wabash Venture LLC. In this case, Wabash is the developer of the Trump Hotel and Tower in Chicago, Illinois. Burke contracts with Wabash to buy a condo unit and 2 parking spaces when the tower is completed for $2.28 million. He pays a deposit of $456,000, which amounts to 20% of the contract price, as required by the purchase agreement. The purchase agreement also contains a liquidated damages clause permitting the developer to retain the deposit if Burke does not complete the purchase. Later, Burke backs out of the purchase and Wabash keeps the deposit. He finds out later that the condo was actually sold for a higher price than the original contract price, so Burke then sues to recover that deposit. The issue here is the liquidated damages clause enforceable? So when the court looked at it, they rejected the argument that the liquidated damages clause was an unenforceable penalty. They say that the later higher sale price was irrelevant to the original contract clause, and it reasons that the 20% deposit was not so high as to be unenforceable on public policy grounds. So they ruled that the developer was allowed to keep that deposit. Rescission is an action to undo a contract. If we rescind a contract, we are trying to undo it. Rescission is available if there has been a material breach of contract, if there is fraud involved, if there is duress, undue influence, or a mutual mistake. Restitution means the returning of goods or property received from the other party when we rescind a contract. If the actual goods or property are not available, a cash equivalent must be made. Adequate notice must be given by the person trying to rescind the contract. And rescission and restitution restore the parties to the positions they occupied prior to the contract. Equitable remedies. So these are remedies available if we determine that money is just not going to cut it. if we need something other than just money damages. And a lot of times they are also available to prevent unjust enrichment. In the opinion of the court, these equitable remedies rely heavily on the opinion of the judge involved. Some types of equitable remedies include specific performance, reformation, and injunction. Specific performance means that the court is going to order the breaching party to perform the acts as promised in the contract. So basically forcing the person to do what they said they were going to do. Reformation is an equitable doctrine permitting the court to rewrite a contract to express the party's true intentions if we find that some language in the contract just didn't really state clearly what the parties meant to have happen. The court would have the ability to go in and rewrite a part of that, or maybe even eliminate a part of the contract. An injunction is an order from the court prohibiting a person from doing something. It's an order for somebody to stop doing something. So we have an example case here for specific performance. It's Alba versus Kaufman. In this case, Kaufman and Kakache own 37 acres of real property with a farmhouse they use as a weekend and vacation home. They live in New York. Kaufman lists it for sale for $350,000. The Albas offer the asking price, and Kaufman accepts the $350,000 offer. Before closing, Kakache notifies the Albas that they have a change of heart and no longer wish to sell. The Albas do intend to continue to closing, but upon closing day, Kaufman refuses to show up to close. The Albas sue seeking specific performance of the sale. The issue at hand here is an order of specific performance of the real estate contract warranted in this case. So the court, upon looking at the case, finds the Albas were ready, willing, and able to close. They find that Kaufman's unwillingness to close is not grounds for cancellation of the contract or a defense to a request for specific performance. It finds that specific performance is appropriate in a real property contract action because each parcel of real property is, and it orders Kaufman to specifically perform the property sale. Arbitration. We've talked about this before. In case you've forgotten, arbitration is a non-judicial private resolution of a contract dispute. In arbitration, we hire an arbitrator to hear the case and make a decision. The arbitrator would act kind of like a judge would in a traditional court trial, but the rules are much more relaxed. It's designed to be faster and cheaper than the traditional court system. There are pros and cons to arbitration. I'll leave that up to your opinion, whether or not it's a good thing. Most arbitration agreements stipulate binding arbitration, meaning that an arbitration decision cannot be appealed to the traditional court system. And oftentimes, once an arbitration decision has been reached, it cannot be appealed. So you're just kind of stuck. The Federal Arbitration Act is a federal law supporting the use of arbitration in legal disputes, both federal and state. So in North Carolina, arbitration clauses are acceptable. There are a very minority of states that ban them, but here it seems to be just fine as long as you are reasonable and not unconscionable. So we have an example case, Mance versus Mercedes-Benz USA. In this case, Mance purchases a Mercedes-Benz E350, which is distributed by Mercedes-Benz USA. Mance signs an installment contract as part of the purchase. In that contract, there is a binding arbitration clause. Mance experiences numerous problems with the automobile and feels Mercedes-Benz USA has not satisfactorily made repairs. Mance then sues in U.S. District Court for breach of warranty and alleges the arbitration clause is unconscionable because it gives him limited appeal rights. Mercedes-Benz motions the court to compel, which means force, arbitration. In other words, they're trying to get it out of the traditional court system and into arbitration. The issue here is the arbitration clause enforceable? The court, upon review, finds the arbitration clause was highlighted, apparent, not oppressive, and Mance should not have been surprised by it. They find Mance's unconscionability argument fails because conclusiveness is one of the primary purposes of arbitration, and the clause gave him the option to suggest from which company to select an arbitrator. The court granted Mercedes' motion, forcing Mance into arbitration. A couple of torts associated with contracts. So the first one we'll talk about here is intentional interference with contractual relations. This happens when a third party induces a contracting party to breach the contract. The elements I have to show is that there existed a valid enforceable contract between the contracting parties, the third party had knowledge of this contract, and the third party induced the other party to breach the contract. An example could be, let's say Google approaches an Apple employee who is working under a contract and entices them to breach their contract with Apple to come work for Google. Now, Google, having knowledge of this contract that existed between Apple and its employee, would be probably held to intentionally interfere with contractual relations. The second tort is a breach of the covenant of good faith and fair dealing. This is an implied covenant, meaning it's not expressly stated in the contract, probably. But it means that the parties are held to the express terms of the contract. It requires all parties involved to deal fairly in all respects. A breach of this implied covenant is a tort for which damages are recoverable. It is implied in contracts where the parties have special relationship that involves a fiduciary duty. So this could be an insured party with an insurance company. It could be an attorney-client. It could be a CEO with or a member of a board of directors with their company. There are a lot of types of relationships that involve that fiduciary duty. An example here. So let's say an insured driver has a policy, an automobile policy, that has a $200,000 limit for personal injury. The insured driver causes an accident and the injured party sues for $1 million. The injured party offers to settle with the insurance company for the $200,000 policy limit, which would be considered a reasonable offer, but the insurance company refuses and the case goes to trial. At trial, a jury awards the injured party $1 million. The insurance company, however, is only going to pay their $200,000 policy limit, which leaves the driver personally liable for the remaining $800,000. Whoa, it's a tough situation. Good for us, or good for the driver, that the insurance company could be sued for a breach of covenant of good faith and fair dealing for refusing the reasonable settlement offer. That wraps up this lesson. Have a great day.